What is the extent of Congress's power under the Commerce Clause of the United States Constitution? The power of Congress under the Commerce Clause extends to intrastate activities that affect interstate commerce, which make regulation of it appropriate to reach a legitimate purpose. Filburn owned and operated a small farm in Montgomery County, Ohio, with cattle and poultry. With some of his land, he grew wheat to feed his animals, to sell at market, and for personal use. The purpose of the Agricultural Adjustment Act is to control the wheat market, to allow the Secretary of Agriculture to determine crop allotments, and to allow the Secretary of Agriculture to conduct a vote among farmers regarding the quota. Filburn sowed 23 acres and harvested from his 11.9 acres of excess acreage 239 bushels, which under the amended Act constituted farm marketing excess, subject to a penalty of 49 cents a bushel, or $117.11. In the Act, Congress extends federal regulation to production not intended in any part for commerce, but wholly for consumption or personal use on Mr. Filburn's farm. That Mr. Filburn's own contribution to the demand for wheat may be trivial by itself is not enough to remove him from the scope of federal regulation, whereas here, his contribution, taken together with that of many others similarly situated, is far from trivial. The definition of market and its derivatives in the Act related to wheat includes selling it, but also disposing of it by feeding livestock. This means that the marketing quotas not only embrace all that may be sold, but also what may be consumed on the premises. Penalties apply equally, whether the wheat is intended for sale or personal consumption. The Court has gradually broadened its interpretation of Congress's authority under the Commerce Clause. The Court determined that commerce among the states was not a technical legal conception, but a practical one, and that the effects of many kinds of intrastate activity upon interstate commerce were such as to make them properly subject to federal regulation. Surplus wheat-producing states supply many states where wheat production is below the level of consumption and export. Large surpluses of wheat and production have devastated the market, and farmers have needed government assistance to sell their crops. The effect of consumption of homegrown wheat on interstate commerce is due to the fact that it constitutes the most variable factor in the disappearance of the wheat crop. This is unlike the amount of wheat consumed or used as seed, which varies relatively little. The power of Congress over interstate commerce is absolute and may be exercised to its utmost extent. It acknowledges no limitations other than those that are prescribed in the Constitution. This power of Congress under the Commerce Clause extends to intrastate activities that affect interstate commerce, which make regulation of it appropriate to reach a legitimate end. The essence of regulation is that it can restrain self-interest and give advantages to others. These conflicts in our system are properly left to Congress to resolve and not the judiciary. If the Supreme Court can find that the Commerce Clause applies here, think of the many ways it could be manipulated by the government to regulate the marketplace. How could this decision be used to affect change in today's marketplace? Can you think of any examples?